All rise. The Court of Appeals, Division 1 is now in session.
Thank you. Please be seated. Good morning. We're here for oral argument in case number CACV 220291, Coronado v. Coronado. These proceedings are being video and audio recorded, so we ask counsel to please identify yourself and your client at the beginning of your argument. Each side will have 20 minutes, and appellant's counsel is responsible for watching the clock to reserve a portion of that time for rebuttal if desired. Also, we have read the briefs and have discussed this case in conference. And before I have you proceed, if we can have someone check the lights and make sure that they're all on, please. This happens sometimes with afternoon oral arguments. So with that, counsel, you may proceed.
May it please the Court, Michael Ellsworth on behalf of the appellant, Robert Coronado. There's an old saying that says, bad facts make bad law. I guess the opposite of that would mean that good facts would make good law. And this case has a lot of good facts. And I just want to briefly go through the timing because the argument regarding ARS, the interaction to ARS 25408 and ARS 25411, the issues with service of process that have been raised, really hinge on these. So in September 28th, there was a letter drafted that was sent, I'm not exactly sure when it was received by the appellant, of the mother's intent to relocate the child to what she called at that point was the greater Phoenix area, I believe, so Maricopa County. We then, on October 8th of 2021, approximately about 10 days later, we had a final hearing on the family law on the petition for dissolution case. October 28th of 2021, the appellant on his own, pro per, filed a petition to prevent the relocation of the child. It's important to note at the final hearing on October 8th, nothing was ever raised, at no time was raised by the appellee of her intent to relocate the minor child. Then the trial court issued a decree of dissolution on November 8th of 2021, laid out parenting time on pages 6 and 7 of that for the appellant, and then on page, I believe, 18, had the appropriate Rule 78C findings, that there were no matters pending at that time, and it was a final and appealable order. We then go forward to November 22nd of 2021, so really just a few days, a couple weeks after that, a motion to withdraw was filed by my office, which ultimately the court granted. We then jump December 4th of 2021. So less than 30 days after the court issued the final ruling, a petition for the relocation was filed at that point by the appellee. The court, having set a hearing on that, held a final hearing on December 14th of 2021, 10 days after the petition was filed. The court entered an order after a 1-hour hearing on that same date. That order did not contain the Rule 78C language, but ordered appellee's counsel to draft the findings in order. That was never done, so on February 8th of 2022 now, a motion to compel was filed to ask for appellee's counsel to go ahead and draft those findings and order. That was never addressed by the court, but the trial court on March 1st, 2022, issued its own order, and again, didn't contain that 78C language, On March 28th of 2020, an expedited motion was filed by my office with the trial judge asking the judge to address that issue. And unfortunately, that wasn't addressed until December of 2022, where there was an amended order. So those are the facts of this case. When we relate it now to the ARS 25408 and 25411 interaction, we know, pursuant to the case law cited in our briefs, that for the court to allow a modification pursuant to ARS 25411, there would have to be one of two circumstances within that 1 year time period. Either that the child was basically, current environment was immediately placing the child in danger, or after a 6-month period of noncompliance, then a party could come back and seek a modification. It's important to note that in the petition that was filed for relocation, now mother, instead of, according to her letter, moving to Maricopa County, now suggested, not prevent the relocation, to have the relocation. Mother's petition to relocate now suggested she was going to Connecticut. And her reason for that was financial situation due to the fact that she couldn't gain full-time employment. So we have that issue of the interaction here, and as a practitioner, and maybe just being in a rural county up there, I don't know if we deal with this more often than not, where we have longer distances, or maybe people travel or coming to the valley. But this is an issue that frequently comes up, and this issue of coming back within, literally with this, less than 30 days after the court issued an order. And it's important to note in that decree of dissolution, the trial judge made specific findings on the 25403 factor, talked about the relationship that the children had with both parents in this case, and specifically, our focus was on father, granted him parenting time of overnight parenting time. And then we go to the judge's ruling on the relocation, where now it's even hard to tell from that ruling what parenting time the father has. It seemed to suggest he would still have overnights of weekends, but he would have to do that either in Connecticut or somehow travel or share the cost of travel. Just clearly that maximizing the party's parenting time, frequent, meaningful parent time was not ordered by the judge. And so we do believe that the judge, in holding a relocation hearing based on that petition and based on those facts, was untimely. And it's important to note that was by the appellee, that they never agreed with that. They never suggested, well, maybe there was something wrong here, or maybe this should have been done in a different way. We then also have the service of process issue that was raised.
Staying on the timeliness issue for a moment, just to make sure that I'm following. We have an order permitting relocation about a month after the entry of the decree, when 411 says you've got to wait a year. We have a case from the Arizona Court of Appeals that says a relocation that affects parenting time counts under 411. And I've been scratching my head a bit, because it does seem from this record that there was an objection to the court considering the law based on non-disclosure, and the court treated the case as though it were an exhibit and precluded it, then proceeded to ignore both it and the statute it had applied. Is anything I just said wrong?
That is not wrong. And I would know, Judge, I believe you're referring to the Weber case, is when the appellant showed up that day. And the reason he showed up, and I believe it's as we had articulated, was I got an email copy of the petition to relocate. I forwarded that to my previous client and suggested that he needs to seek counsel, needs to do something regarding this, and provided him with that Weber case. Mm-hmm. And then appellee, through her counsel, the counsel for appellee is the one who objected to that case.
Counsel, just to clarify, I think you mean Murray.
Murray,
yes.
You're correct, Murray.
Yeah.
Thank you. They objected to that case because it hadn't been previously disclosed, and I think we raised that in our reply brief that.
Yeah, I'm just struggling to see how an argument like that even gets into court. the law is not evidence. I think we would agree on that basic proposition. The law is the law, and the courts are bound to follow it. So can you help explain how this situation could even arise? Because this may very well be the last argument I hear, and I've got to say, in my entire career, I've never seen an argument like this made.
Can I be very candid?
Please.
The trial judge we had is very inexperienced, not well trained, didn't have the, prior to being elected, I don't believe really practiced in the area or had the experience, and then came in and relied maybe somewhat on appellee's attorney for that, or just didn't look at the law.
So appellee's trial attorney, though, advanced as a serious legal argument to the court that a case could be disregarded because it wasn't admitted as evidence. Is that correct?
I believe that's correct, and that's what we put in our reply, that's just not accurate. And that's one of the reasons, too, and I'll just briefly, one reason why we're asking for attorney's fees in this case is because of the unreasonable position that's been taken throughout the proceedings to include suggesting that service of process had been effectuated because he showed up that day.
Okay. The situation with the admitting the case as evidence strikes me as sufficiently bizarre that I wanted to make sure I wasn't reading too much into the record or misunderstanding this. So I appreciate the clarification.
Well, thank you. So just real briefly, are any other questions, Judge Cruz, Judge Patton, on that issue? Thank you.
No, you may
Just
continue.
real quickly on the service issue, and I'll just touch on it briefly and then allow some time for rebuttal in the end, is there was a suggestion that because the appellant came to the hearing on December 14th and appeared, that somehow he had at that point waived service or service had been effectuated. And I believe looking at the rules, an appearance can acknowledge service of process, which we suggested then the service of process would have been on the date that he showed up. And pursuant to the rules, Rule 91 of the Arizona Rules of Family Law Procedure, and service of process rules, Rule 40 of the Arizona Rules of Family Law Procedure, and Rule 41, 20 days would have been needed before the court could set a hearing or would have a hearing after the service of process. So furthermore, his due process rights were violated.
That was a little unclear to me from the briefing. You're suggesting not that this petition should have been rejected for lack of service of process, but rather that the lack of service of process deprived your client of the time to which he was entitled to respond under the rules?
Well, actually both. We don't feel the judge should have found that he was served on that date. But if looking at the rules, and the court did not articulate at that point.
But just a moment before you get further from here. So you don't believe that the court should have found he was served at that moment and set the matter over?
Well, the court could have. I think the court had two options. One, the trial judge could have said, look, service of process has not taken place. Or it could have said, you did appear today, which the court said, pursuant to the rule, we're going to find now that service of process has taken place today, and let's set an appropriate hearing and allow you to file a response.
Did father ask for a continuance?
I would have to go back and check the record, but I believe he did, and that's why the trial court said, well, no, you're here today, we're just going to proceed.
I'm curious also, based on the short time between the evidentiary hearing and the filing of the petition, what exactly were the purported disclosure deadlines? Do you know?
I don't believe there were any issued by the judge in that case.
And the disclosure deadlines under the rules, even if they somehow required you to admit cases into evidence, would not have run between the time that the petition was filed and the hearing was conducted, correct?
Would that be correct? And we would normally rely on, without a written order from a trial judge, the family law rules, which Rule 49 would tell us, and Rule 76 related to pretrials, which clearly would have at that point, I know the rules have just changed, but would have been 20 days prior to a trial or hearing that those would have to be disclosed.
Thank you.
Okay. So appreciate your time this afternoon, but we do believe the trial judge erred both on the issue of service of process, violating his due process, and allowing at that point, the appellee to even file a petition to relocate and specifically to grant that petition to relocate. Thank you. I'll reserve the rest of my time for some rebuttal.
Thank you.
Good afternoon, Your Honors. My name is David Martin. I'm here representing Holly Coronado, the appellant in this case. I'll be referring to her as Holly. Robert's opening brief, I'll be referring to the appellant as Robert, raised two issues. One was the adequacy of service. Our position on that, as stated in the opening brief, was that he appeared.
And what about the time?
Pardon me?
What about the time?
The timing of the hearing on the 14th, from the date, he had notice that my client intended to relocate, albeit to the Phoenix metropolitan area, back in September.
That doesn't matter. The rules require that parties be given a certain time to respond. And that didn't occur here. The rules also require that parties have a certain amount of time to disclose things that are actually subject to the disclosure rules, and it appears that didn't occur here.
With respect to the time, Your Honor, ARS 25408 simply says at subparagraph C that my client is allowed to request in the affirmative that she be allowed to relocate the children. This is not a petition to prevent relocation. It's a petition to permit relocation, and that part of the statute says that upon notice, that can be heard.
So you can file a petition for relocation and not even serve process. Is that what you're saying?
No, that's not what I'm saying. I can file a petition to permit relocation, and if the hearing is set and the opposing party appears, then under Rule 40F3, it's the same as being served.
Well, I agree with you that if a party appears at a hearing, the issue of service is effectively waived. But this case adds a different wrinkle. Let's say you brought a civil action. You filed the complaint on Monday, and the court set trial on Friday. I think that would probably violate the provision that you've got 20 days to file an answer or otherwise respond to the complaint. This wasn't a TRO. This was a hearing that was set very quickly, very aggressively, and while the actual need for service is waived if someone appears, the time that they should have to respond and prepare their case, I would think, still applies, no?
I'm hearkening back to Rule 40 with respect to your analogy to a civil case, allowing 20 days in which to file an answer on a civil case.
Right.
And frankly, I'm having a little bit of trouble plugging that analogy into this scenario.
Okay, so in this scenario, if process had been effectively served, how long would father have had to respond to the petition?
On a petition to permit the relocation, the statute itself does not provide any time. It simply provides upon notice. That's 408C.
No, but the rules still apply, don't they?
The rules do apply.
Because the statute doesn't contain any provision covering waiver of service, waiver of notice, anything like that, like some other statutes do. This statute just says there can be notice, you can file, and I suppose we can argue about whether 411 applies to 408. That argument might actually be informed if we all read Murray and treat it as law rather than fact, but we'll put that aside for a moment. 25408 doesn't say anything to undercut the applicability of the rules governing the conduct of evidentiary hearings, including the time frames that give people due process. Correct?
Correct.
Okay.
And Rule 91, I believe, which in turn refers to Rule 40 and 41, says that or it said at the time, I think it still says that Mr. Coronado could have filed a response up to 3 days before the hearing. So there's a modified period of time in which he could have filed a response, and it was actually 3 days before the hearing that he could have filed a response.
How do we know that he knew of the hearing date 3 days before the deadline, or before the hearing?
The petition to permit the relocation was sent to former counsel because the address that was given for Mr. Coronado when counsel withdrew was the marital residence that had been awarded to Holly. We knew that sending it to that address would be a nullity. So we sent it to an address that we had where he resided with his mother, the Coconino Way address, and we, in an abundance of caution, copied Mr. Ellsworth as well, even though he was off the case. And we believe that, I'm not sure if it's clear in the record that the order issuing the December 14th hearing date it was not served on Mr. Coronado for sure. But you know that he had notice of it. You don't know exactly when he had notice of it because the record is not clear when he got notice of it. But obviously he got notice of it.
Right, but we don't know if there's no way for us to know whether he got notice of it that morning, let's say.
You don't accept that in the record, in the transcript itself. There's some reference, and it's somewhat muddled, but Mr. Coronado is saying that he at first didn't get any notice from his attorney, and then upon questioning did indicate that he had notice.
Well, he was there.
Right,
we
he
know
was
that
there.
he got some notice somehow, but we don't know the timing of that. We don't know when that happened. That could have happened that same morning.
You don't know when. He didn't articulate it, and I don't believe it's reflected anywhere in the record.
Right.
Did he ask, just one more question,
sure.
Did he ask for the matter to be set over to another date so he could have an opportunity to respond?
Not expressly.
What did he say?
He alluded to having talked to his former attorney. He alluded to what his attorney told him to say, but he didn't ever expressly come out and say, I need more time, I want to continue this hearing, or even words close to that.
Okay.
I mean, I've heard of a rocket docket, but this seems to have been set so quickly that I can't think of one time frame anywhere in the family law rules that was complied with in this case. Can you?
Judge Warren, I would ask you to also consider, however, that we did ask for an expedited hearing on this. We explained the need for an expedited hearing because of my client's financial stress was created not only by lack of employment, but by lack of child support.
Well, but if you need something expedited that quickly, there are provisions for proceedings essentially akin to temporary restraining orders or preliminary injunctions. There are highly accelerated proceedings that themselves have rules to protect due process. I don't see that there was any consideration at all given to due process. And as long as we're talking about time frames, when were his disclosure deadlines?
His disclosure deadlines would have been prior to the hearing, within at least 3 days, I would submit, by analogy to his response time.
So he had about 2 days then, assuming that he had the notice we don't know he had, early enough, he would have had about 2 days to make his disclosures.
Because we don't know if he got notice on the date the petition was sent, which was December 4th, and we don't know if he got it anywhere between, we know that he got it somewhere,
right,
but we don't know exactly when. It's pure conjecture as to whether or not he had time between December 4th and December 14th to simply disclose the case of Murray versus Murray, which he did not.
Well, we'll get to Murray in a second, but might it not be a good idea to avoid this sort of speculation to simply comply with the rules? They're not suggestions, they're rules.
Understood. And because he was there and didn't expressly ask for a continuance.
No. I'm talking about, the next thing we're going to talk about are his disclosure deadlines. Mm-hmm. When did you make your disclosures?
I made a disclosure, I'm not sure I can answer that, Your Honor, in a very informed way. I I provided in my intent to relocate some propositions for settling the case.
In other words, you never served a disclosure statement.
After the
Right.
filing of December 4th, I did
After the
not.
petition to relocate was filed, you never served a disclosure statement, and yet, even though this hearing was noticed faster than any relocation in Arizona history, probably, you tried to hoist him on his own petard by saying that he didn't serve disclosures. Is that what happened?
No, that is not the case at all.
Okay,
When
what
he
happened?
presented Murray, I simply said, I've not seen this, and if you'll see in the transcript where I said, I haven't seen this, I'd want an opportunity to review it, is what I said.
I believe in the transcript you also object to it on the basis of non-disclosure.
I did.
And nobody in this case served disclosure statements, which are required by the rules. And of course, nobody had to serve them before this hearing because the disclosure statement timeframes in the rules would have extended far beyond the hearing date.
I think the disclosure statement could have been due within 3 days of the hearing, based on the provision of Rule 91.
Okay, so now let's talk about authority. Murray is case law.
Correct.
In what universe is case law evidence?
It's not.
Okay, so when the court precludes case law and refuses to, quote unquote, admit it as evidence, is it not your responsibility to inform the court, as an officer of the court, that it has strayed far from any known law?
At the time when it was being presented on December 14th, I had not reviewed that case. I took the time to review it in my answering brief. I did address it. I didn't say it wasn't the law. I simply distinguished it.
Your answering
from
brief is in this
case.
court. I'm talking about in front of the Superior Court. It happens all the time that people cite authority you may not be aware of. Is it your view, under the law, that a court can reject a case on the basis of nondisclosure and refuse to, open quote, admit it as evidence, close quote?
No. No, that's
So
not my
you would
view.
agree with me then that that is effectively a lawless part of this proceeding?
I would disagree with that respectfully.
Okay.
I would disagree with it because the judge at that point didn't take the step of saying, well, just hold on here. We're going to continue this to give Mr. Martin a chance to address the Murray case that Mr. Coronado just came up with today that was handed to him by his former attorney.
I could cite a case for you right now that you've probably never heard of. That's not a ground to continue this oral argument. You have to think on your feet sometimes, and you have to do the research before you come to a hearing. And quite frankly, anyone practicing family law should know about 25-411.
I was aware of 25-411. It's my view that
And Murray is a rather mundane application of 25-411, but I'm still trying to figure out how it is that the trial court either was allowed to or on its own strayed so far out of any concept of the distinction between law and fact that it treated case law as evidence to be precluded. I'm not concerned with the fact that you didn't know about Murray. I'm concerned with the fact that the very definition of law and fact seems to have eluded everyone in this proceeding.
I think respectfully, Your Honor, you're concluding that Judge Hardy was entirely unaware of Murray when she made her ruling. And I think if you look at the extensive ruling from March 1st, I don't think that she was unaware of it.
Well, if she was aware of it, she sure didn't cite it here.
She didn't cite it.
And she sure didn't follow it.
But her detailed analysis of the factors under 408 suggests that she did go
Except
through
Murray
all
is
of
not
those
about
factors.
408. Murray's about 411.
It is
She
about-
did not address 411.
She did not address 411.
Okay. So
But
she may have had some idea of what Murray is, but the fact remains that she ruled, and this wasn't in passing, it wasn't a mistake. First she ruled that she was going to let it in, then she ruled that she was not going to let it in. Cases don't get let in. That's not the way the entire American legal system works. So how is it that we are here talking about such a basic proposition today?
I think that the judge was caught up in whether or not it would be admitted as an exhibit. I don't know that you can necessarily read into it that she was deciding to ignore the law simply because it would not be admitted as an exhibit as it was offered.
All right, I have a question regarding relief in this case? Assuming for a moment, let's just assume for a moment that Mr. Coronado did not have a full opportunity to be heard because he was not served and he did not have sufficient time to respond. Or that the petition should not have been filed prior to a year. Assuming that there's relief to be had, what would that relief look like, in your opinion?
If there was relief to be had, Your Honor, I think what the relief ought to be is a very close look at the extensive determination that Judge Hardy made under the Rule 408 factors. She went through a whole bunch of detailed findings regarding financial stress, regarding emotional support, and let us not forget, too, that arguably a part of 411 was addressed arguably, by the fact that Mr. Coronado was living in a van at the time, and that was brought to the court's attention with respect to the facilities to be able to visit the children, and his parenting time was not entirely stifled thereafter.
So would
the
it
point
be a
is,
matter
what
of
difference
sending
would
it
it
back
make?
so that the court can make the 411 findings it didn't make before?
I think so, Judge. I think on the appellate level, there should be some consideration to, would there be a different result given the body of evidence that was presented? I guess that's what I'm inartfully trying to say, is that we did present evidence and the judge did make that finding, even though, and let's not lose sight of the fact that procedurally, Mr. Coronado did not object within 30 days to the petition to relocate, even though I realized the time was not up. He did, though, file a petition to prevent relocation on the notice that issued on the September 28th date, and he didn't show up for the same hearing.
But this is all in the prior proceeding, pre-dissolution decree.
The notice was pre-dissolution hearing and final hearing. However, the date in which he failed to appear was November 22nd, 2021. Which was after the October 8th final hearing. That's what the trial judge was confronted with. So get back to your question, Judge Cruz. I'll try to answer quickly. I think the very first step in the appellate analysis is, if there was error, is it harmless error? Is it error that, if relief is granted, would it make a difference based upon this record? There's been no demonstration within the briefing that it would have made any difference at all. And with respect to the briefing, too, when you look at the parenting time that he was granted under the March 1st, 2022 order, it's difficult to compare, at least as a matter of advocacy, what the prior order was, because there's no citation to it in the opening brief in terms of what the prior parenting time order was. So if we're looking at May and we're looking at 411, how much does it really impact his parenting time? The biggest and obvious one is that it's in Connecticut. That's what the judge ordered.
But from our perspective, the law says that there have to be findings made as to 411. Do we ignore that, or do we send it back so those findings are made now that we're a year later?
You don't ignore it. You send it back with, if you determine that the findings that she made are insufficient under 411, then, and I would submit they're not, but if you do make that finding.
But counsel, you just said that the court cites nowhere in her order to 411.
She doesn't. But she does cite to 408 extensively. But
how can we get to 408 without first finding an exception applies in 411?
Much of what's in 408 is also covered in 411. In fact, I think the way the statute is written, 408 alludes to the other factors in 411, and I think those are inherently present in the words that she used going through 408.
This is actually the reason that we have rules for orderly court proceedings, because if they had been followed, the parties could have discussed whether the petition should have even proceeded to an evidentiary hearing in light of 411. But of course, because this was set for trial so quickly, with no pleadings, no discovery, no disclosure, the court never had a chance to even consider, and the parties never had a chance to argue these issues. But one thing to me seems clear. The court entered an order that 411 prohibits and did not make a finding that any exception to 411 applied.
I don't believe Judge Hardy mentioned 411 in her March 1st, 2022 order at all. She referred to 408
I think we agree on
extensively.
that point, yes.
She referred to 408 extensively. And
Terrific.
the elements within 408, compare them and line them up against 411, are very, very similar.
Well, the problem is that 25411A says that a person shall not make a motion to modify legal decision-making or parenting time earlier than 1 year unless the court permits it to be made on the basis of affidavits that there is reason to believe that the child's present environment may seriously endanger the child's physical, mental, moral, or emotional health. And so we don't have those affidavits. And so the court did not make that finding that it was necessary to have this hearing for those reasons. And if I understand your argument correctly, you're saying that if we look to the findings that pertain to 408, we can extrapolate enough to meet the 411 requirement. But I'm not sure that we can find therein the affidavits that would have been required, so it still would be deficient, wouldn't it?
It would, and it was waived at the time. Mr. Coronado showed up without an attorney. He had an attorney just previously to this.
But no,
and he didn't object
He may
to
have
that.
waived service of process, but he is appealing, not waiving, the procedure that was held below, and that's what brings us here now.
He could have and should have raised on December 14th the fact that there was no affidavit. There was a petition. I'm
Well, he tried
struggling to say whether it was verified or
he tried
not.
to raise 411 via Murray.
He raised Murray, but he did not argue that there was no affidavit. That's
All right.
not in the record.
All right.
You're
any-
holding this pro per father to a standard of legal excellence that does not seem to apply in your argument either to your filings or to the court's rulings. You're asking a pro per litigant without adequate notice, without even time to worry about securing counsel, to make every legal argument to perfection. And yet when the court ignores literally every rule in the book, you argue that that should be affirmed. That troubles me.
Mr. Coronado did not, and I realize I'm out of time, Your Honor, but I want to try to answer your question. Mr. Coronado did not come into this case as a babe in the woods. He had counsel throughout the extensive history of this case. Numerous proceedings where temporary orders were not followed. You just look at the record on appeal.
I think since we're out of time, let's stick to the actual issue. You can talk about his history all you want, but the fact is the court did not follow any rules in this case, not one. I cannot think of a single rule of family law procedure or a single provision of ARS 25411 that the court honored.
The court honored 25411 when it addressed 408 in detail.
Okay, thank you.
Thank you, Your Honors.
Thank you.
Thank you. In the decree of dissolution on page 6, the court under parenting time said, until father finds stable housing, father's parent time will be in his current RV home, only if parked in a safe condition. So this premise that, the child now is in danger because father's living in an RV, the judge knew it at the time of the decree of dissolution and actually made a provision regarding that. So really her premise for filing for the petition to be able to relocate was based strictly on her inability to find employment. I also found in the transcript from the hearing that was dated December 14th, 2021, on page 7, Mr. Coronado says to the court, so Michael Ellsworth withdrew from my case in November. A petition was filed in December, and I had 20 days to respond to it. So pursuant to Rule 91, at least he had been informed that he had 20 days to respond, which I was never given, and this is him to the court. I was also not served with the papers, so my lawyer got an email, but he's not my lawyer representing me anymore, and I never received any. I was never served with this. It's interesting, down at the bottom of the page, Judge Hardy says, this is a petition for relocation, so it has separate requirements. again, candor, and I practice in front of Judge Hardy all the time. I've had probably 30, 40 cases or more since that time in front of her, but she just didn't know the rules. We then go on to page 30, this question about whether he requested. Mr. Coronado said, I would like to get the opportunity of 30 days to get or speak with my attorney so he can represent me in this case. Court said, okay, why didn't you bring that up in the very beginning? That's like opening and starting type issues. And then we go into the Murray issue as part of that, and how there was an objection by appellee's attorney as to that, and those type of things on there. So this, again, it troubles me a little on the service of process that we seem to think that notice is service of process. That seems
Well,
to
it can be. You would agree that if there's a failure of service of process and one attends the proceeding, that is a waiver of service, yes?
Yes, pursuant to the rule it is, but they seem to suggest that because they had notice, if you review, and I believe the even opposing counsel said a little bit, well, he got an email, so he knew of it, so that was service. We also know, as referred to in our reply brief, that service of process by email is only post-petition. That can be waived and agreed upon in writing. So when they kind of rely on that, that's not consistent with the rules as far as service. And again, there was never any suggestion today at any time that says, here's the efforts we took. We went and got a process server and tried to show up at his RV or at his old house. We sent it to him by certified mail, and it didn't come back. There was nothing to that.
Let me ask, so what now? Assuming that we agree with your client's position, your opening brief requests that we vacate, we vacate the order permitting relocation. So how does that happen?
Thank you. And I'll go a little on experience on this, is we seem to get this catch-all sometimes, at least been my experience of practice of almost 19 years now. Well, we're not going to follow the rules at times, or we're going to let something in, maybe admissibility issues, because we're just going to say, well, it's the best interest of the kids. It's like we take the rule book at times and we throw it in the trash and say, well, best interest of the children. What is the best interest here? The judge found in the decree what was the best interest and determined that fathers should have parenting time, set out a parenting schedule, talked about how that would be done. Then, less than 30 days later, with no change in circumstance, except for mom couldn't get employment for 30 days.
Right, we understand that, but are you suggesting that we're going to follow the rule and not give the court flexibility for how to carry out our order vacating? In other words, vacate the prior order, even if that means bringing the child back to live in a homeless shelter so father can have parenting time, or can we order that the court consider 411A and fill in the blanks of what was not done then, ignoring the fact that some time has passed and circumstances may have changed? That's what I'm asking.
Yes, and I appreciate it. I'm sorry I was taking a long way of getting there, just going back. But yes, that's what we're asking, to vacate that order, require the mother bring this child back to Arizona. She had a home to live in. She actually got awarded the home in the decree of dissolution. So she had a home. Dad's parenting time was in an RV, but it was very brief. It was from, I believe, Saturday morning until Sunday evening, or very short periods of time, but still provide him that opportunity. So father needs that, because in the best interest of these children, right now, their ability to see their father and have a relationship with their father is minimal. And we know from our legislature that it's public policy of the state of Arizona to promote strong families. And so we are asking that she have to come back, bring this child back, and ultimately go through the process. I know I'm out of time, and I appreciate being able to be here today. We do feel that I feel this would be a wonderful case based on the facts. I say wonderful, but we would ask the court to consider publishing this case, because I think it gives a lot of direction. One, service of process, due process, and also on this correlation between 25408 and 411, because clearly mother's petition for relocation had no facts in there to suggest that these children were in immediate or almost imminent physical, mental, or moral danger in their current circumstances with their mother in the house that she had been awarded. Thank you.
Thank you, counsel. Counsel, we thank you both for your arguments, for your briefing. This matter is now taken under advisement, and we will issue a written ruling in due course. We're at recess.